deal with foreign relations and foreign affairs, but making this a little bit more of an internal matter. Our panel at 3:30 is the President's power to implement international law after Medellin v. Texas. Okay, so we're a little bit case specific on our touch point here, but the panel will address this broadly, I'm sure. Your chair for this afternoon's panel, number 4, is Jonathan Adler, who holds the Johann Verheij Memorial Professor of Law seat and is director of the Center for Business Law and Regulation here at Case Western. Jonathan?
Thank you. I'm going to be incredibly brief because none of you are here to hear my opinions about Medellin versus Texas. But we have a good panel on this, and for those of you that don't recall, I'm just going to say a tiny bit about Medellin versus Texas and why it's an important case. Certainly in international law circles, it's considered an important case because one of the issues it involved was the extent to which decisions of the International Court of Justice or perhaps even other arbitral entities are binding U.S. law that are enforceable in U.S. courts. And that was one question that the Supreme Court was called upon to consider. But the other issue that was called upon to consider was the extent to which the President had the authority to make a decision by an international tribunal or an otherwise non-self-enforcing treaty obligation enforceable in domestic courts. And politically, this case has been quite interesting because of the alignments it tended to produce, in the sense that those that are often fans of executive power were not fans of executive power in this case because of the way executive power was being yielded. And the Supreme Court in Medellin had held that neither a judgment of the International Court of Justice nor the presidential memorandum could direct state courts to comply with a judgment of the International Court of Justice as federal law enforceable in state court. And it arose out of the context of a habeas appeal by a non-citizen death row inmate who had not been informed of his right under the Vienna Convention to have access to the consulate of his country of citizenship. And this certainly has broader implications for the implementation of international law domestically, and as I'm sure at least one of our panelists will mention, it's probably one of the few recent Supreme Court cases that so far this year has received regular mention on the stump by at least one political candidate for federal office. But anyway, enough from me. I'm going to very briefly introduce our panel. Full bios of all of them are in the booklet, as with everyone else. First, we will hear from Kristofer Monson, who is Assistant Solicitor General for the state of Texas and who worked on Medellin versus Texas. Then we will hear from John Quigley, who is the President's Club Professor of Law at the Moritz College of Law at Ohio State University. Then we will hear from our own Cassandra Robertson, who is an Associate Professor of Law here at Case Western Reserve. And then we will hear from Melissa Waters, who is Vice Dean and Professor at the Washington University School of Law. So that's enough with me, and Chris, the floor is yours.
Good afternoon. I've come to realize as this day has gone on that I am in a minority in 3 important ways leading into this speech. First of all, I am a full-time practitioner and litigator. Second, I work in state, not federal government, so that gives me a slightly different perspective that's going to inform what I say to you today. And third, what I expect is a small minority who thinks that Midian versus Texas is an unabashed good for the Republic and represents an important bulwark in ensuring that there is some relationship between the governed and the government, and that it turned out absolutely right and was the best possible rule that could be applied. Of course, the court did accept our argument from our briefs and used our research, so I'm a little bit biased in saying that, but I still think it's true as a normative as well as a political matter. And Cassandra here actually worked with us at the time, and she's urged me also to tell you the story of how I got involved in this case. And that is the Jessup International Law Moot Court Competition. This is kind of a shout out to all you all international law instructors and the good folks who run Jessup, because I have like the Jessup Cinderella story. I walk off my clerkship into my first job. We're there for 6 months. I pick up this binder, I'm like, ooh, this looks interesting. It's got public international law in it. It had kind of been languishing. No one was really paying attention to it. And it kind of got up to everybody's attention. It came into our office. And then I was like, I can bring in my Jessup file. So we ran the public international law part of both Medellin cases and Bustillo. I drafted the state's amicus in Bustillo and Sanchez Lamas from my Jessup court materials. So it just goes to show that that some of this does matter. And I got to tell you, having been thorough in that research was very useful in my actual professional life. Medellin has a kind of a tortured history, right? It started as a habeas petition, and it started with our kind of ordinary, run-of-the-mill capital habeas folks. And the way our system works is my office only gets involved in certain very important cases, usually that are either media sensations like Midian ended up being, or involve sometimes more boring cases, but usually that involve problems of governance and deeper systemic issues of the exercise of public political power. So Medellin, and I have some of the chronology on this a little bit mixed up, so you'll have to forgive me. So we'll have to the actual facts. Medellin was trying to invoke the ICJ Vienna decision, which in turn referenced several other decisions the ICJ made, that the Vienna Convention on Consular Relations created an international obligation to give individual citizens access to their consulates in the process of criminal convictions and detentions. He had procedurally forfeited the claim in state court. And so the real question was, and you can't bring up a procedurally forfeited claim for the first time in federal habeas corpus proceedings under the AEDPA. And so from our point of view, this was actually not that different from most of the rest of our docket. It's a question about how do you figure out who gets the say on what happens with an AEDPA claim. So we brief it up that way. It looks like this is going to be the case that decides the effect of Avena's interpretation of the Vienna Convention on, both the named Vienna plaintiffs and some other folks that are also, at least say that they are subject to the Avena decision. And it didn't turn out that way. Shortly before we went up to Washington, D.C. for the argument, the president issued a memorandum. And it was, I think when people talk about Medina, I think they forget how strange the memorandum was at the time. The memorandum was weird. I'm still not sure what it meant. Famously, during the CCA, the Court of Criminal Appeals proceedings in Texas, Michael Dreeben was representing the United States, and one of the judges leans over real close across the bench and goes, "Mr. Dreeben, do you live in Washington, D.C.?" And he said, "Yes, Your Honor." "Do you know the president?" I've seen the president. I've met him. "Well, can you give him a call up there in the White House and ask him what this thing means?" Because we don't know. Which kind of colored the rest of the proceedings. In the end, the CCA, in a phenomenally fractured opinion that I'm not going to even try to recount because we didn't rely on any of their justifications in the United States Supreme Court, I think they fractured like 8 different ways, and there's only 9 judges. And it was, they decided that Medellín's claim was procedurally defaulted, and it goes up. And so the questions in front of the United States Supreme Court are, does the treaty apply to Medellin of its own power, or does something about the president's interaction with the ICJ's interpretation of the treaty or his foreign affairs power generally give the memorandum, whatever it meant, binding power that would have required Texas to waive its procedural default rule? And, I guess, once again, we looked at this case the way we look at every case. Yeah, I've been thinking about how public international law is kind of this hothouse issue, right? It's sovereigns versus sovereigns, and there really isn't much case law to go on, and you can't really, get into the nitty-gritty with the way you can with torts or contracts. And my practice too, my general practice is about the role of the states and the federal government, the role of Texas' extremely complicated separation of powers doctrine, the role of the respective parts of the Texas government, how you justify the exercise of government coercive power. So we did what we always do, and that's we try to think of a rule that will help us win. This is where being a practitioner is going to come out. I tried to come up with a rule that's going to work for the future, that's going to let us win, and that we could hypothetically lose under. So I think that those are the three elements to winning any case like this. You never want to be in a situation where you're the Red Queen saying, I'm always going to win. That's bad advocacy. I think that that kind of colored how we looked at the case. And certainly my Jessup experience had also colored it, because I had come out of Jessup with the feeling that international law doesn't really mean much. And it's really a set of political negotiations that we dress up in order to resolve the interest of different sovereigns. The other thing that I think we had as a goal, and I think underlines the majority's decision, is to restrain the court's ability to say what international law means in a way that was going to interfere with the structures that legitimate democratic governance in our federal system. In other words, that we weren't going to let the states go quietly into that good night, such that the foreign affairs power was going to be a carte blanche to write exceptions to duly enacted, neutrally applicable state court principles. It's kind of funny, Andrew's sitting right here. In law school, we were in this seminar on energy deregulation, and we wrote 2 papers on opposite sides of the same issue, which was like power line placement and NIMBY. And I wrote that I thought that if you don't have a mechanism for incorporating NIMBY concerns into power line placement, then you're not validly exercising sovereign power, because you're not giving voice to the people on whose votes you depend to use the sovereign power. And she said the opposite. I was right. I think she got a better grade, though. And so I think that's the real fundamental interest that I see Medellin as encompassing, because what I think it does is it removes the haze of specialness that the foreign affairs power has in the kind of federal court's jurisprudence of how much power the president has, and it puts it on an equal footing with things like Chevron deference and the other ways that we think of the allocation of power, either between the branches of the federal government or between the federal government and the states. And that's, you have to anchor it to some textual hook, and then that's the springboard from which the power to exercise power comes. If you don't have that, I think this is doubly important when you're talking about a court issuing a judgment, because courts, and it's our common law tradition that courts function better with specific facts and specific things to think about. And a guiding principle is, if the legislature has acted, they can displace the court's ability to make policy decisions and normative decisions, such that we spend a lot more time now than we did 150 years ago talking about what Congress meant, how Congress articulated its intent and exercised sovereign power on behalf of the people. And so I see Medellin as being of a piece with all of the federalism cases. It's like Florida prepaid, and they're running out of my head, but in the same way that Congress has to at least articulate a basis for invoking the 14th Amendment, or we're not going to presume that Congress meant to implicitly preempt state law. I see Medellin as being a gathering in of the foreign affairs power into the generic, ordinary, plain vanilla law that we have for saying whether federal government action is constitutional on a day-by-day basis.
Thank you. Mr. Monson and I have one thing in common. By virtue of our roles on this issue, we are not unbiased. My bias is as strong on the other side as his is on his, by which I don't mean to demean his arguments or to undercut mine, but this whole issue of consular access is one that actually came about from lawyers in Texas unrelated, much earlier than Mr. Monson's activity. In 1993, there were some lawyers there working in a federally funded office who had clients. One was from Canada, one was from the Dominican Republic. My wife, as it happened, was down there as one of the lawyers representing these people. And one day she called me on the phone here in Ohio and said, "Do you know anything about a treaty called the Vienna Convention on Consular Relations?" And I said, gee, well, I have a vague recollection about it. Well, to make a long story short, this turned into a little cottage industry. She and others filed cases in Texas, generally without much success, on behalf of foreign nationals. These were people on death row to try to get some court to look at the fact that they had been denied access to their consulate, or that they had, more precisely, they had not been informed of the right of access at the time of their arrest. Very soon the Mexican government got very active in this, and she and I got involved with the Mexican government and did work with them. We began writing pleadings for international institutions, the Inter-American Court of Human Rights, which was asked for an advisory opinion by Mexico, and then the International Court of Justice, where several states filed against the United States, and as well the Inter-American Commission on Human Rights, before which we filed several petitions claiming that different foreign nationals had a right to a review of their convictions for the fact that they had not been informed of their right of contact with the foreign with their consulate. Eventually, I began writing articles on this. One of them, actually, Michael Kelly, in his organization, gave me an award for Article of the Year on this. So I think Michael can't disagree with anything I say here today. I think you're stopped. But and then we got involved with the European Union, which very strongly is interested in the issue of capital punishment and also the issue of consular rights. And they began filing amicus briefs in courts in the United States, and my wife and I wrote those briefs in the Sanchez Lamas case, in the Medellin case. So I'm very much on one side of the issue. I don't conceal that. But the Medellin case then came out of the fact that after Mexico got the ruling from the International Court of Justice that there's about 50 Mexicans on death row in Texas were entitled to review and reconsideration of their convictions on the basis of the fact that they had not been informed at the time of arrest of their right of access. The question arose, what was going to happen with that? How was that going to be implemented? And Medellin, as Mr. Monson said, happened to have a case in the U.S. Supreme Court already at the time that this occurred, at the time at which President Bush decided what to do. And I also agree with Mr. Monson about the way in which the president acted. He, in effect, wrote a little Post-it note to the Attorney General saying, I think this should be handled by the state courts. I mean, it was a very odd mechanism. Whether it was a directive of the president to the states, one can raise a legitimate question. But I think it was accepted that way. On the basis of that statement by the president, Medellin's lawyers decided to file a new habeas corpus petition in the courts of Texas, figuring now that they had the president behind them. Before they only had the treaty behind them. Now they've got the treaty plus the president. As it turned out, this was a huge error on their part, because by the time the case got back to the Supreme Court, there was a fellow named Alito on the court in place of someone named O'Connor. and that pretty much doomed the defense from the get-go. But the case then went to the court, which made an absolutely ridiculous decision, with due respect to whatever was written by the state of Texas in its brief. Actually, one of the things written was that a treaty is not self-executing if there is a mechanism in the treaty for implementation or enforcement. And in the UN Charter, Article 94, which is the relevant article, there is a provision that you can go to the Security Council of the UN in the event of non-implementation. That is, a state that is a party to a case before the International Court of Justice that fails to comply, the other state can go to the Security Council. So Texas came up with the argument that meant the treaty was not to be self-executing, in that treaty provision was not to be self-executing in the courts of the United States because there was an alternative. It was contemplated that there was a different way of dealing with it. That's a fine argument, except that there are countless treaties that have alternative mechanisms of enforcement, and the U.S. Supreme Court has never had any difficulty finding their provisions to be self-executing. So this was something entirely new, and why the Supreme Court accepted it, I won't speculate, but in my view, the court should never have dealt with the self-execution issue at all, because this was not a situation in which an individual was simply relying on a provision of a treaty and saying that I come within the class of people who are given rights under this treaty. It was different in that you had the president attempting to enforce it against the state. So in effect, this case was the president against the state. And there has never been a case in the U.S. Supreme Court or in lower courts in which the concept of self-execution has been invoked when it is the president that was seeking to enforce a treaty against a state. There are a number of cases of that sort that have come up that I recite in this article where that was the situation, and no one ever mentioned the idea of self-execution. Self-execution is only relevant if you have some individual who says the treaty provides me with a right. So in my view, there should never have been the self-execution issue at all. The U.S. Attorney General actually agreed with what I'm saying in the case. After Texas filed its brief, the U.S. Attorney filed an amicus brief and said self-execution is irrelevant in this case. But the U.S. Supreme Court immediately, at the beginning of its opinion says the question here is the self-execution of Article 94, paragraph 2 of the UN Charter. And then they said because of the fact that there's this alternative method of compliance, therefore it's not self-executing. They also said it's not self-executing because of Article 59 of the Charter of the UN, which says that decisions of the International Court of Justice are binding only in the case. And the U.S. Supreme Court took that to mean, that means they're not binding in the courts of the United States. Well, most law students that have taken course in public international law know that Article 59 was put in there to mean that decisions of the International Court of Justice were not to be taken as precedent in the sense in which we have precedent in the common law world. It had nothing to do with the subsequent implementation of a decision of the court. To my mind, the court erred in dealing with self-execution at all as an issue, and when it got to self-execution, it botched it horribly. Now, the good news is that my estimation is that because this decision is so ridiculous, it's not going to be followed very much by the lower courts. And I write about that in my article. There's a piece in the Yale Journal of International Law by Professor Una Hathaway at Yale who says the Medellin case means that we're not going to have any self-execution on any treaties. And the points are points that relate to minor statements made in the case, one being that in order for a treaty provision to be self-executing, there has to be some explicit language in the treaty that says that it should be self-executing. That's something that's never been required by the U.S. Supreme Court in the past. And fortunately, the U.S. Supreme Court in Medellin does cite the old cases, which are entirely inconsistent with this concept. They also have a little footnote saying that there might be a presumption against self-execution, which is something you don't find in the case law as well. But I looked at cases decided by lower courts under the Convention on International Sale of Goods, which is a self-executing treaty, and the lower courts are applying it since Medellin without even a glimpse at Medellin. The same true of friendship, commerce, and navigation treaties. There's a major treaty with Japan, which incidentally has a clause on an alternative dispute resolution mechanism, and but the courts are continuing to apply that without any problem. The same with double taxation treaties, which similarly are self-executing, and the courts are continuing to apply them, and they don't mention Medellin at all. I'll stop there. Okay. All right.
Okay. So I did not work on the Medellin case, and public international law is not my area. I'm going to actually take this about 90 degrees and look at what the impact is, if anything, on Medellin on international civil litigation and litigation procedure. So as you've heard, the Medellin case has a number of different aspects to it. Most commonly, it can be read as a death penalty case, a federalism case, an international human rights case. I think it is all of those things. What it is not is a case about ordinary civil litigation, which is why it seems kind of interesting then that the majority in Medellin would actually go out of their way to disavow any intent to bring the case into ordinary civil litigation. The court writes that, quote, its holding does not call into question the ordinary enforcement of foreign judgments or international arbitral agreements. It's interesting, though, because the very fact that they need to disavow any intent to enter into this area kind of raises a question by itself about, well, how could it come into this area? And here I think the court's concern is probably warranted. The court is certainly correct that there's no direct effect on ordinary judgment enforcement. But indirectly, I think it does shift the conversation and shift the risk in some ways that I argue could ultimately harm the nation's foreign policy interests and ultimately its economic interests. I don't take a stand on whether the case was legally decided correctly. I will say, having worked with Chris, I would never bet against him. He's a fabulous attorney. So I'm really just looking at the policy impact of where do we go from here and how does Medellin maybe move the ball a little bit in terms of civil litigation. So there's certainly no question that issues of court access and foreign judgment enforcement certainly implicate foreign policy and economic vitality. Professor Stephen Burbank has written quite a bit about how what he calls the geopolitical ramifications of international commerce interact with the domestic judicial system. Over the last 3 decades, the big challenge has been how to deal with the United States' role in transnational litigation. Historically, the United States has been a very significant magnet forum for worldwide litigation. The availability of higher damage awards, very liberal discovery policies, and very accessible courts have made the U.S. courts a very attractive destination for foreign plaintiffs. On the flip side of that, of course, it has made United States courts a very unattractive destination for foreign defendants. But since plaintiffs generally have priority in forum choice, a number of lawsuits have been filed in the United States, and it has been a magnet forum. This is something that's been changing, though, in recent years, especially, I would say, in the last decade, as both commerce and commercial litigation are entering a more multipolar era, and you're seeing more civil cases filed worldwide. So as parties perceive a greater freedom in forum choice for transnational lawsuits, the foreign policy of court access becomes ever more important. If the United States is viewed as an uncooperative judicial partner, nations might retaliate and have to some degree already retaliated by enacting legislation that makes their own domestic courts more attractive to suits against especially U.S. multinational corporations. Some of these policies also actively discourage investment and trade by some of these same multinationals, potentially putting U.S. corporations at a disadvantage. On the other side, historically in the United States, the country has had a very generous judgment enforcement policy that has been a very unilaterally generous judgment enforcement policy, which has made it difficult to enter into an international agreement on enforcement of foreign judgments. So where does Medellin move the ball? I think it does this in a couple of ways. The most obvious one is it makes it a little bit more difficult to implement a multilateral convention on judgment enforcement or to implement the Hague Choice of Court Convention. In fact, if there is a default presumption against self-execution, then that suggests that there will be another step in the process for getting some of these commercial treaties to be implemented. But even more than that, I think it raises a suspicion in our negotiating partners' minds that the United States might simply not be acting in good faith in some of these negotiations, that it might not be a good partner, thus making negotiations just a step more difficult. There is a second way I think that Medellin moves the ball a little bit, and that is in its encouragement of state participation in some of these court access decisions and international decisions more broadly, and especially in attitudes towards the role of international law. So at the current time, I would argue the domestic political landscape does include a significant xenophobic strain, and this strain comes into play, especially I would argue, when states are given a bigger role in the implementation of some of these agreements. So for example, people have argued on the other side that state participation doesn't necessarily impede progress in the area. They've pointed out that even prior to Medellin, some states were very deferential especially to the ICJ decision. So for example, in Oklahoma, you had the governor and the court system in Oklahoma pre-Medellin working to ensure that the Avena decision was respected, and in fact, a death sentence was commuted. I would argue, though, that in spite of the fact, or perhaps not in spite of the fact, but perhaps because of this very deference, you saw a political backlash. I think it's no coincidence that Oklahoma is one of the states now where the voters have voted in favor of a constitutional amendment that actually prohibits the courts from giving any deference to international law at all. Of course, there are constitutional issues, U.S. constitutional issues with the Oklahoma provision, and it hasn't yet been given the force of law. It's been enjoined by federal courts. But the fact that 70% of the voters in Oklahoma voted in favor of excluding any deference to international law suggests that state participation is at the least going to make things a bit more difficult. Of course, xenophobia and nationalism are not going to prevail in every state, but overcoming such attitudes, even when those attitudes are in the minority, is going to require the expenditure of additional political capital that I argue is in very short supply in the current highly partisan and polarized environment. Voters in such states are typically focused on some of the more newsworthy issues of international law. They tend to focus on death penalty questions, on anti-terrorism initiatives, and your average voter is definitely not thinking about transnational commercial litigation. But even voters who are focused on these more high-profile issues, if given power, will certainly have a power that affects even this kind of bread and butter commercial litigation that is more common. I would also be concerned that introducing such partisan political distinctions will create enduring shifts that might then become solidified in a more enduring way. We've seen certainly that Medellin has become something of a political rallying cry, especially I would argue for members who identify with the Tea Party, including a former boss of ours who argued the Medellin case. But it has been used in a way to suggest that, as another author has written, that foreign forces are succeeding in taking over the United States, transforming the country they love into an unrecognizable and alien land. In a rhetoric of foreign invasion and foreign infiltration that dominates its speeches and literature. I think it's questionable about how to define the Tea Party, but certainly I think there is an element of this in some of the rhetoric that we see. So even an international convention that's focused on issues of civil procedure that are boring to most voters can then be reframed as a very partisan political issue. The Hague Convention on Choice of Courts, for example, does obligate the judicial branch of signatory nations to suspend litigation in favor of the country specified in a choice of courts clause. Even this then could be reframed in a partisan political matter. And so I would argue, even though Medellin is certainly not a direct impact on international civil litigation, I think it does represent a noteworthy shift in the process of international lawmaking, one that moves power to the states and to the legislative branches of government and away from the president and away from the federal government. Thank you.
So first I want to thank Michael and Jonathan and Nancy and everyone else here at Case Western. I actually began my career at Case Western years ago. I think I was supposed to come for a semester, and 2.5 years later I was still here having a great time, and I think the folks here just took pity on me and didn't want to tell me it was probably time to move on. So it's always great fun to come back here, and I really just love this conference. So thanks very much for that, Michael. Chris and John have admitted their biases, so let me admit mine too. I think Medellin is, let me think. Yeah, I want to say this. I think Medellin is the most fascinating case of the past 10 years, 15 years. So I really applaud Michael for saving the best for last with this panel. I don't mean my own presentation necessarily, but I really think this is great stuff. And so let me, I want to set this up for you. So I actually speak on Medellin to our 1Ls every year. And so let me set this up for you the way I set it up for the 1Ls. And this will maybe help you see just what a great case this is. So picture this. You've got a bunch of human rights lawyers who come to President Bush and they say, "Hey, President Bush, we've got these Mexican nationals, some of them sitting on death row down in Texas, that state where you were governor, and we've got this ruling. It's from this court. It's called the International Court of Justice. It's one of those international courts you love so much, and it says that these guys are supposed to get review and reconsideration of their of the criminal convictions against them. And you know what we'd really like you to do, Mr. President? We'd really like you to issue an order ordering the state courts down in Texas to give these guys what the ICJ says they're entitled to. What do you think?" And at that point, I always ask my students, "So what do you think, what do you think President Bush did?" And of course, they all laugh knowingly because, of course, they're all very smart 1Ls, right? And then I read to them. So we were talking a little bit about what the president actually did. Here's this weird Post-it. I liked that. I liked John's Post-it note memo. Here's what he said. He said, "I have determined, pursuant to the authority vested in me as president by the Constitution and the laws of the United States of America, that the United States will discharge its international obligations under the decision of the ICJ, etc., by having state courts give effect to this decision." So you'll notice he never ordered them. He never directed them, but that's pretty clearly, I think Chris would say, that's what he meant, right? That's what he meant. So it was this odd thing. Now, for those of you who are thinking, wait a minute, was President Bush just having a particularly bad day? Why in the world would President Bush, of all people, do this? Well, take heart. He actually delivered a 1-2 punch. So lest the human rights lawyers be too happy with him, he said, "Oh, by the way." So essentially he was saying, "Chris, just give me this, right? Just give me these 51 Mexican nationals, and here's what I'm going to do for you, right? I'm going to withdraw the United States from this optional treaty that gives the ICJ jurisdiction over these cases again. So give me these guys, and then you'll never have to deal with this issue again." It was very clever, actually, on President Bush's part. So this is really a case that I think turns all expectations on their heads, and it makes for some very strange bedfellows, which I think is why it's such an interesting case. So you have human rights lawyers who found themselves in bed with a president that, let's be honest, they could not stand, arguing for what? A robust understanding of presidential power in foreign affairs. At the exact same time that some of these same people were arguing for not so robust an understanding of presidential power in things like Guantanamo Bay, treatment of detainees, the terrorism cases, that sort of thing. And on the other side of the aisle, you had folks who found themselves torn between their support for robust presidential power in foreign affairs and their staunch commitment to this little thing called states' rights, right? Ordinarily, those two things tend to go together, right? And keeping the federal government out of something that is really intimately state-oriented, right? There's nothing that we think of as being more the province of the states than the administration of criminal justice, right? So our topic then is the president's power to implement international law after Medellin, and what's been the impact of Medellin on the president's power. And this, I think, is really a crucially important question because in a globalizing world, the distinction between what's international and what's domestic is really breaking down. And more treaties are touching on what have traditionally been exclusive domestic issues, like criminal law. And so let me just take a step back and consider with you a little bit the broader context. So this, I think, is really the context that Medellin is coming from. So think about it this way. So if you think of we've sort of got two worlds out there. We've got international law world and domestic law world, right? International law world and U.S. world. And the question is, how do these two worlds interact with each other? And so when the United States enters into a treaty over here in international law world, there's no question it gives we have binding obligations in the international law world. The question is, what happens in the domestic law world? Especially if it's something like this case that actually touches on domestic issues. What happens? Well, there are various approaches that different countries take to this question. Some countries say, anytime we do anything in international law world, it automatically has effect in domestic law world. Those countries are called monist countries, right? So we enter into a treaty, it's binding in domestic law world. Other countries say, that's crazy, we're dualists. We say, we do something in international law world, it doesn't take effect in domestic law world until there's something that sort of crosses over. And essentially what that thing is implementing legislation by the legislature in these countries. Well, the United States, of course, this would be far too easy. Lawyers wouldn't have anything to do if we just chose one or the other. So we decided we're going to be a hybrid country. We're going to treat some treaties as self-executing. Those are the ones that automatically take effect, right? And we're going to treat other treaties as non-self-executing. Those are the ones that require implementing legislation by Congress. So that really, I think, is what was one of the big battles here, at least as Chief Justice Roberts conceived of it and as the parties argued the case before the court, is what about the treaties involved here? Are they non-self-executing, in which case you got to have implementing legislation, or are they not? And so what I think Medellin really represents is a pretty striking shift on the part of the court that we've seen in other contexts as well toward dualism, toward a very dualistic approach to international law, and toward this notion of, look, just because we do something in international law land, even though it's binding on us in international law land, it doesn't mean that it's binding on us in domestic law land, right? So the question then is, in a dualistic world, which institutional actor serves as sort of the intermediary between the domestic and the international realms. And in Medellin, Chief Justice Roberts made it very clear that if you're talking about implementation of a treaty obligation into domestic law, so crossing over from international law to domestic law, Congress is the intermediary. It was very clear about that. Chris won that point very decisively, right? So it said, look, the president just does not have the power to take a non-self-executing treaty and translate it into domestic law. Only Congress can do that because we're dualists, we're not monists, right? The Bush administration, I think Chris also alluded to this, the Bush administration had also argued, hey, but I, the president, surely I have independent foreign affairs authority. It's not really clear exactly where that comes from. I think that's Chris's point, but there's some sort of independent foreign affairs authority apart from the treaty that I should have to implement the ICJ's ruling. And the court said, nope, you don't have that either. So in short, if Congress isn't going to help you out here, then Mr. President, sorry, you don't have any power and there's nothing that we can do. So then what's been the impact of Medellin? So the immediate impact of Medellin has been huge. President has no power to implement this international obligation, the ICJ's ruling that we're supposed to give review and reconsideration to these Mexican nationals, many of whom are sitting on death row. Everyone, by the way, agrees on one point. We are required under international law to give effect to that ruling. We're actually required in international law land to do that, right? Because the Supreme Court said, President, you don't have the power, essentially they left it in the hands of Congress. And anybody want to guess as to whether Congress has done anything? Of course not. 4 years later, Congress has not acted. And Medellin was actually executed 5 months after this decision. So immediate impact of Medellin, I think, with respect to those Mexican nationals has been huge, no implementation. What about the broader, longer-term impact of Medellin on the president's power to domestically implement international law obligations? Well, I think we need to divide our treaties into two categories here. On treaties that we're going to negotiate and sign in the future, I think Medellin may well result in significant changes in the behavior of future treaty makers. I think what's going to happen is that the President and Congress in negotiating future treaties are going to be a lot clearer, I think, on is this a self-executing treaty or is it a non-self-executing treaty? If it is non-self-executing, whose job is it to implement whatever treaty obligations flow into domestic law? I think it's certainly possible, by the way, that even if they say it's a non-self-executing treaty, I think it's certainly possible Congress is still going to delegate a considerable amount of power to the president to implement any treaty obligations that flow from that treaty. Finally, what about Medellin's impact on the president's power to implement treaty obligations for those thousands, by the way, of treaties that are already on the books and that might actually have implications in domestic law? Keep in mind that the Vienna Convention on Consular Relations, nobody really thought that this was a treaty that was really going to have a serious impact on domestic law when it was negotiated. The provision that we're talking about is one teeny tiny provision in a treaty that's really all about consular relations stuff. No one really was thinking it was going to go after state criminal law. So what about Medellin's impact on that? I know I'm out of time, but give me just 2 more minutes. I actually think it may not be that significant in the grand scheme of things. I think this is where John and I agree. So we all know bad cases make bad law. Unusual cases tend to make unusual law that tends to get ignored or worked around. And I think Medellin is both an unusual case and bad or at least hopelessly confusing law, but not for the reasons I think Chris is now thinking I think that they are. I think we agree more than he thinks we do. So 2 reasons why. First, I think Medellin is sui generis. Medellin, the issue of consular notification, this is really, to my mind, a proxy in a much broader fight over the use of the death penalty. And one could easily see subsequent courts distinguishing other kinds of cases, trade, civil judgments, that sort of thing on that ground. Secondly, it's not a particularly well-written opinion. So even if you agree, and I think the arguments that the state of Texas made were perfectly reasonable, even if you agree with them, I just think Chief Justice Roberts just doesn't really understand self-execution doctrine. There are lots and lots of problems with his opinion. And by the way, this is actually not at all unusual. Those of us who write in this area, if you look at cases where the poor Supreme Court has to deal with international law or foreign relations law, they get it wrong all the time because it's hard and they just don't get that many of these cases. And it's not just a conservative justice thing. Justice Souter, you should see the hash that he made of extraterritorial jurisdiction in a case called Hartford Fire. And so what happens to these kinds of opinions where the court just doesn't get the doctrine right at all? Forget the, who's right or who's wrong, just doesn't get it. They tend to get ignored by later courts, or they tend to get worked around in various ways. And I actually think that that's what's going to happen in this case. The really notable thing, this is my last comment, the really notable thing about Medellin, I think, is this pretty decided shift, which is part of a broader trend toward a very dualistic approach in which the Supreme Court says, look, just because something happens in international law land doesn't automatically mean that thing is also happening in domestic law land. Is that a good or a bad thing? This is where I'm going to say I kind of agree with both of you guys. I think it really depends. What do we want? So if we have a more dualistic approach to treaties, then what that means, Chris is absolutely right. It means that it means that we'll have more democratic input into how international law impacts domestic law. But the downside, this is my last thought, the downside is it really makes it very, very difficult for us to implement our international law obligations, which has some pretty serious negative effects with our treaty partners. And I'll stop there. Thank you.
Okay. To start off, I didn't know if any of our panelists wanted to take a moment to respond to anything that anyone else said. If Chris,
I just wanted to point out that there are several ways to explain away all of those treaties with individual rights in them, consistent with at least my understanding of self-execution, which is that if the text looks like it's conferring a right, then you can tell from the text that the agreement was to do that thing. if there's any ambiguity in the text, then you can't tell. That it's just like Congress acting. If Congress doesn't act with specificity, it can't act under the 14th Amendment. It's no different from that. And so I think that that's the distinction that's going to save all of these individual rights creating treaties from Rauscher on, because they are different in kind from what you had to deal with in Midian, because the treaty itself is an odd duck in the way that this one subpart of a treaty that the introduction and the travel preparatoire clearly say wasn't meant to create individual rights, ended up working its way from the President to the Senate.
Are you talking about Article 36 of the Vienna Convention now, or Article 94 of the UN Charter?
Well, I would say I was talking about Article 36, because I was
but
also
that was
thinking...
not an issue in the Medellin case.
Well, right, but I think you have to read Bustillo and Midian together to really get an idea of where the court's going on self-execution generally. I also think that there's a practical consideration that there are a lot of treaties, let's put aside whether they have some form of arbitral decision-making in them, that reference the United Nations. I think there was a desire to not let the ambiguities in Article 94, and there are ambiguities. I mean, anybody who's done justice knows that you argue Article 94 and Article 53 and Article 51 up and down, and then you flip sides. I mean, that's what it's all about. There is a very practical desire to not make all of those cases automatically self-enforcing through UN mechanisms. And I think that's a defensible policy decision.
Yeah. I think in terms of this federalism issue we've been talking about it kind of in policy terms, but nobody has mentioned, and this is in part a factor of the limitation of time, we do have a constitution in this country, and it has an Article 6, and it's called the Supremacy Clause. Thank you.
Exactly what I was going to talk about.
Yeah, right. And here's something that was written about that clause. If a treaty does not supersede existing state laws as far as they contravene its operation, the treaty would be ineffective. Does that sound reasonable? Now, that was written by James Madison. I think the Tea Party wouldn't object to James Madison,
But to turn it around, if the treaty itself was susceptible to a reading using the tools that the judiciary has, because I think part of the problem that the international law community has is you're taking these broad academic theories and you're squishing them into what courts know how to do. The courts know how to look at text. The United Nations Charter is not clearly and unambiguously create these kind of obligations. I mean, I think that once you start applying the tools that the American courts have and have developed against this background of federalism to interpret any source of legal authority, they're able to look at that and say, look, that's vague enough that we're not going to count that as a law. And there's nothing, the power to say what the law means is also the power to say that's not law.
But you shouldn't be talking about the UN Charter as a whole. You're only talking about one provision, and that's always the issue with self-execution. You're not talking about a treaty as a whole. Obviously, even the Vienna Convention on Consular Relations has many provisions that you couldn't argue would be self-executing. But with the Medellin case, the only point at issue was the self-executing character or not of Article 94. So you can't go to the provisions of the UN Charter about the General Assembly and the budget and say, are they self-executing?
But, I'm going to push back again and say that's what a court does. A court looks to the totality of the document. The introductory portion of the Vienna Convention tells us what Article 36 means.
Hold on a second, though. So let's keep in mind, and we may be getting a little too into the nitty-gritty for the audience here, but let's keep in mind that historically, there are plenty of Supreme Court cases where I think you're suggesting, Chris, so I don't disagree with you, but I think you're suggesting that the question of whether a treaty is self-executing or not is a question of interpretation of the text itself, right? And sort of textual, hold on, let me finish, textual understanding. And that's certainly the way Chief Justice Roberts looks at it. I think in doing so, he really ignores, and the dissent clobbers him on this, I think effectively, he really ignores a lot of precedent where the Supreme Court makes it clear that the self-execution question is not just a question of reading the treaty text. It doesn't make sense to analyze self-execution questions just as a question of, gee, what's the treaty say on whether this treaty is supposed to be self-executing or not? That couldn't possibly work because you have so many countries who don't even look at the question of self-execution versus non-self-execution. In other words, that's a U.S. problem, so you can't resolve that problem of self-executing versus non-self-executing by looking just at the treaty text. So you have to take into account all of these external factors. factors, and that's what he didn't do.
Well, yeah, internationally, law speaking, right. But if you're looking in terms of actually implementing sovereign will in our Constitution, if you don't have that hook, you can't attribute an intent to the President and the Senate to accept those terms of the treaty.
The question is, what is the hook? Are you looking for a textual hook?
Well, I think there
Why?
has to, because that's how you tell what a body, the President and the Senate together, is deciding. You look at text.
In other contexts, but not, historically, not in the context of self-execution.
But it wasn't a big deal before. You know, most of the treaties that are found to be self-executing actually do on their face create individual rights. So really, in those cases, like Rauscher, for example, the statute says these individuals shall have this right. So when you look at the treaty, its ratification, even under Justice Robertson interpretation, cannot but have meant.
I'm sorry, Rauscher case, there was no statute involved. It was a treaty. You
Oh,
should be
sorry, the
talking
treaty.
about
I'm sorry, the treaty.
And
But
the treaty says absolutely nothing about someone in Rauscher's position. The treaty says the United States and Britain agree to extradite people back and forth. That's all it says. And then the court said, well, in extradition law, we have this principle. I'm getting too much into a case that people don't know about, but the court said that the question of whether someone who is extradited on charge A can subsequently be indicted on charge B. This is something that flows from the general law of extradition. That is, there's an understanding when you extradite on charge A, the person cannot be put on charge B. There's nothing at all in that treaty about individuals at all.
But that is wrong. That is wrong from a point of view of American law implementing sovereign power, right? Because the specialty provision had to be implemented through the specific text, otherwise it wasn't going to apply. Now we have a provision that says, by statute, that specialty is going to apply. But absent that text, you can't divine an intent on the part of the United States to enter into an agreement that was going to give that right.
Here's if I can just jump in for a second. I want to add a little, at the risk of adding additional complexity to Medellin, I want to get the folks on the panel to address one question about the case, and the extent to which it matters, which is part of, time of the background on the case, the Texas courts actually did consider Medellin's Vienna Convention claim in the sense that he raised it, they heard it, and they said this was procedurally defaulted, and there was no prejudice. The reason they argued there was no prejudice was because he had confessed, I think within 3 hours or 6 hours of being arrested. Under the Vienna Convention, he was only guaranteed the right to contact the consulate within 72 hours. So his confession occurred before the state had failed to fulfill its obligation. And so Texas argued, plausibly at least, wouldn't have mattered, too late, we could have taken him to the consulate 10 minutes after he confessed. The confession would still be good, no prejudice, and this was also procedurally defaulted. The interesting legal question that I wanted to raise is the other aspect of Texas' argument, which I don't think plays very heavily in the opinion, but to some of us that look at federal courts, this seems to be a big issue, is that Texas courts claimed they had no jurisdiction to consider this again and could not reconsider this after Havana or the president's memorandum because there was no new law for them to consider. But had Congress enacted a statute, and this came up at oral argument for the case, enacting a statute expressly guaranteeing the rights even just of the 51 individuals in the event of decision, there would have been a new legal basis, and the Texas courts would have had jurisdiction, and this whole problem would have gone away.
Well, the federal court, the federal government, through President Bush, had purported to grant that power to Texas, and even perhaps order, I think, despite the ambiguity. And as you say, the Texas courts had already previously decided with respect to Medellin that consular access would not have afforded him anything good. Now, I think they're probably wrong about that because you never know what impact consular access is going to have on a case, and they did it very summarily. And I've got another guy on death row now, one with respect to whom I have a favorable opinion from the Inter-American Commission on Human Rights, which said that he should be released or retried by the United States on the basis that his consular access rights were not respected. A man named Cesar Fierro, and he was arrested in El Paso. The police contacted the police across the border in Ciudad Juarez, who arrested the guy's mother. And then they let him talk on the telephone to his mother in prison, and he was panicked that his mother was going to be, abused in the prison in Mexico, and he immediately confessed. In that case, the Inter-American Commission of Human Rights said there is reason to believe that consular access would actually have done him some good, but he today sits on death row in Texas, and every year since I got that ruling in 2003, the Inter-American Commission sends me a letter and says, we're following up on the compliance by the United States with our decision of 2003. Can you tell us the current status of Mr. Fierro? And we write back and say he's still on death row in Texas. I think that the Medellin case, in a way, was a bad one, because there was, in fact, on the facts, very little going for Medellin, and I think the Texas courts could have dealt with it very summarily. They could have done what President Bush asked and said in 5 minutes there was no prejudice, but I think they might have been worried about cases like Fierro.
And state law that said they didn't have jurisdiction. I mean, it's not just the judges exercising naked policy. That's what our habeas statute says.
There's an interesting sort of Texas jurisdictional point, too, though, which is Texas is one of only 2 states that has both a Court of Criminal Appeals and a Texas Supreme Court, both of which are co-equal and neither of which is bound by the decisions of the other. Because I think that you might have seen a different outcome at the Texas Supreme Court if they had criminal jurisdiction. In the sort of roughly analogous area, not at all analogous as a legal matter, but as a jurisdictional matter, Texas intermediate appellate courts are not allowed to look at remitters in civil courts. Questions of fact the intermediate courts can, the Texas Supreme Court cannot. When the U.S. Supreme Court came down with the punitive damages jurisprudence and says, as a matter of U.S. constitutional law, we think there needs to be de novo review on appeal, the Texas Supreme Court said, well, in spite of the fact that the Texas Constitution says we have no jurisdiction in this area, we have to look at it because the Supreme Court has asked us to. You see this broadening of Texas jurisdiction in that area. I think that the habeas situation is kind of interesting because, it's analogous in the sense of there could be a supremacy clause issue that trumps Texas jurisdiction, but the Texas Court of Criminal Appeals came out differently, as they're allowed to do.
On both legal and policy grounds, I think this is just a horrible decision. And obviously, there are many treaties that do not clearly create rights for individuals. This treaty clearly creates obligations to provide rights to individuals, obligations to the state of Mexico, which took the case to the World Court. And the Supreme Court says, well, if Congress had told Texas to do this, no problem. Well, the answer to that, I think, is Article 6 of the Constitution, which says this Constitution, the laws of the United States which shall be made in pursuance thereof, and, quote, all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding. That's pretty clear to me, saying we don't care what your procedural rules are or what your criminal rules are. You have an obligation to respect this treaty as the president told him to do it. But the policy side of this is people who come to this country and get arrested tend to get due process. You may remember the case of the Alvarez-Machain case, where the doctor who used his medical skills to keep a DEA agent alive while he was being tortured, and then they audio taped it and tossed the tape to us so we'd know what had happened. We worked with them. They tossed him across the border, basically. We took him to trial. We used the Kerr-Frisbee doctrine, where the courts basically unanimously have said, we don't care how he got here, we're going to try him. And he got off because they didn't have the evidence, to convict him. Due process protected him. But this treaty is very important for Americans throughout much of the world where they don't have our due process. And what we've just said is, under the doctrine of reciprocity, don't worry if an American comes into your country and you happen to not like a political button he's wearing, and you throw him into your prison, under the law that says, he's disrespectful of the mother-in-law of the president, and that's a capital offense. We don't have any rights under this treaty because we've just interpreted in a way that Iran, North Korea, they have no legal rights because of this decision. We have given them an interpretation, and under the doctrine of reciprocity, when we interpret a treaty, any other party to the treaty can use that same interpretation to defend themselves. To me, this is the most outrageous thing because it served no useful purpose for us, and it's a flagrant violation of the clear language of the Constitution. You don't need Congress to say this when the people through the Constitution have said it. But I don't know. Most of my friends disagree with me, and maybe I'm missing something on it.
Well, I do think on reciprocity grounds you're missing the fact that no other state will vacate a validly entered criminal conviction on the basis of the Vienna Convention. They consistently, and no one in the litigation has ever come up with a counterexample, offer diplomatic notes apologizing to the United States, but to politely decline to vacate the criminal convictions. Mexico, in fact, has a federal law prohibiting exactly the remedy that they asked for in the ICJ. And so really we've got a situation where these kind of airy principles of international law are being asked to do the opposite of what they said. I mean, you should look at Vice President Xi's seriatim opinion in which he says, look, this is against all the principles of what we do to look at reciprocity. It is an extension of our jurisdiction to order remedies, and yet we're going to do it anyway, and I think we should because of the death penalty.
No, I don't know the Mexican case on this, but I would say if we have challenged these cases, that's one thing. If we haven't, we've just let them happen, but we've just given up any right we have to challenge them by saying it's perfectly all right if subdivisions of the state want to have different rules that denies people any due process rights.
Well, and I would push back that this is not about due process. It's about access to counsel, which may in turn give some additional help to the public counsel that's already provided, at least to capital defendants.
That is a procedural rule, and it is required by international law and through our Constitution.
Well, no, it's only required by the Avena decision. The treaty only says you shall give them access and the opportunity to contact their consul.
Yeah, well, okay. Anyway, we can disagree, but to me it's just an outrageous opinion that serves no benefit to us and tremendous harm to us.
Jonathan, can I just comment on?
Yeah, please.
So for those of you who are wondering, I think it's really helpful that the gentleman read the supremacy clause. That's obviously a good place to start. And so for those of you who are wondering, gee, it does mention treaties, and it says, absolutely, it says that they're part of the supreme law of the land and that the states are supposed to abide by them. If you're wondering, well, then doesn't that resolve this? Are we dualists? Are we monists? Are we, self-executing, non-self-executing? Many scholars have argued convincingly, yes, indeed, that the founders, that if you look at that language, the founders actually intended that the United States be monistic in its approach to treaties, and that when you enter into a treaty obligation, it automatically takes effect. Many other scholars have argued convincingly that there's evidence that the founders did not intend that, or that the evidence is unclear. In my view, I don't really know that just pointing to the supremacy clause really resolves the issue, because whatever the founders were thinking with the supremacy clause, so even if you're an originalist, I don't think that the founders they could not have conceived of a day when we would have the sorts of, good for us, good for the world, the sorts of human rights treaties that we have today. They weren't thinking of treaties in that way. They weren't thinking of international agreements in that way. And so that doesn't necessarily mean that, certainly doesn't mean the supremacy clause is irrelevant. It doesn't necessarily mean that we should not treat all treaties as self-executing, but I think it is an important distinction to keep in mind. And so to my mind, what the court is really grappling with, and again, I think Chief Justice Roberts does it badly, but what the court is really grappling with is, okay, now that we do have these treaties that really touch on issues that are really states' rights sorts of issues, what do you do with that, right? So, for example, could the federal government, there's a famous case called Missouri versus Holland that deals with this, could the federal government, if it doesn't have the power under the Constitution because of the prohibitions on the federal government stepping on state powers, if it didn't have the power to take a particular action, could it just enter into a treaty and do that and impose that on the states, right? So I think the court is really grappling with what do we do with these treaties that sort of impinge on the prerogatives of the states. My complaint with Chief Justice Roberts' opinion is that I just think it's so oddly formalist. I don't actually think he's really grappling very successfully with these issues. He seems to sort of be putting himself in this little isolated box and saying, well, okay, let's just look at the text. And I don't see any evidence that it's self-executing. And so let's just treat it as non-self-executing. And okay, we'll just stop there. And I think that actually a little more bringing to bear what works in this context and how does one balance. Again, let's think conceptually about who ought to be the intermediary. Should it always really be Congress? Is that really a practical solution? Or should it vary depending on the kind of treaty? Maybe it's appropriate in this context because criminal justice is something that's so important to leave to the states. Maybe it's not appropriate in other contexts. Maybe in other contexts it makes sense for the president to serve as the intermediary between the international and the domestic law worlds. And I don't think Medellin gives us any help at all in that more sophisticated analysis of let's begin to think about how to categorize different kinds of treaties that have this impact on various aspects of domestic law.
But this issue of trumping state law is one that is not only, well, it's reflected in what I read from James Madison, but it was decided by the U.S. Supreme Court in 1796. There was a case that was raised by someone who had rights under a treaty, and it went to the U.S. Supreme Court in 1796. These were British creditors who had rights under the Treaty of Paris of 1783, the treaty by which we got independence from Britain. There was a clause there that said any it didn't say British, said any creditors have a right to have their debts honored, and that was put into the treaty because of the fact that the Commonwealth of Virginia had adopted legislation during the war saying that it was permissible if you owed money to a British creditor to pay it to the Commonwealth of Virginia, and that would exonerate your obligations.
Paper currency instead of in pound sterling.
Right. Yeah. And the British were not too pleased with this provision, so when it came to negotiating the Treaty of Paris, they demanded a provision that said that creditors should have the right to get their debts. And that eventually went to the U.S. Supreme Court, and that involved overriding the law of Virginia to carry out the purposes of the treaty under the Supremacy Clause.
But it did so
that's why it's often said by analysts of the Constitution that it was that incident that led to the introduction of the treaty language in the Supremacy Clause of the Constitution.
At the same time, that was a specific right granted by that you can get out from the text, and that a court can use its court-like powers to recognize and say was adopted by the right decision makers. That's what this is really about. If you don't, it's that nub of specificity that gives you the hook for self-execution. And I don't, I think that seems strange in the public international law world, but that's how administrative law and preemption law work. And the courts are just turning their tools for doing administrative and preemption law to treaties.
As a kind of follow-up question on that, I'm wondering the extent to which is, as Melissa suggested, maybe that the focus on self-execution takes the court and discussions of this case down a rabbit hole, in the sense that had the court come out the other way, one could argue the practical effect is that Vienna Convention rights as interpreted and mandated by the International Court of Justice would be superior to rights guaranteed in the Bill of Rights. Because, for example, had Medellin been an American citizen raising, say, a Fifth Amendment or Sixth Amendment claim in state court, and had there been procedural default, and had the state court said there was no prejudice, a federal court would have said, so long as there was reasonable application of federal law at the time, tough luck. And what Medellin was seeking here was more than that on the basis of a judgment of the International Court of Justice. Now, the court never says that, but I'm wondering if that background knowledge, and if we look at, for example, the way the court handles habeas petitions in capital punishment cases generally, that it would have been quite anomalous for the court to come out the other way here.
It's actually relatively simple.
Just wondering.
Yeah, that's true, but this treaty, I think as Professor Turner was saying, provides a right specific to foreigners on the assumption that a foreigner may need a little bit of extra help in the criminal process.
Anyone else?
I agree with you.
Last question.
I mean, we have a long tradition of treatment no less favorable. national treatment.
Right, this would have been more favorable had the court gone the other way.
But that's normal. That's what happens in international treaty making all the time. Countries do that all the time. It's not weird in that sense. I'd like to focus maybe on this concept of the power to implement, this idea that the president tried to state that he had an independent power of implementation, alongside Congress, that where Congress had perhaps not passed legislation, but there were still elements of the treaty that could be implemented by the president absent, as you said, this legislative authority, the sort of passing of implementing legislation. One of the reasons this has come up is because recently, and I think partly as a result of developments like this, the president has claimed the power to have sole executive agreements with respect to something like, say, the anti-counterfeiting trade agreement, where essentially it's a bold statement that I have the power to approve. So the first list is the power to approve, and then they make a sort of reverse argument that, but because nothing is necessarily going to have to change, it doesn't have to go through the approval or legislative process. But yet, clearly, there will be some legislation that may come up in about 5 years that may be contrary to that. Then what occurs in terms of that? So does Medellin provide us any way of talking about those kinds of situations, about the relationship between the president and Congress when it comes to what portions, et cetera, or are we left with the whole treaty is non-self-executing?
I think you can't talk about the whole treaty. The only thing that's relevant here is one article of the UN Charter, Article 94.
Well, and the other thing I think we have to keep in mind is that the president, like the executive of any sovereign, has the ability to ignore international obligations and suffer the consequences, and that Congress has the ability by legislation to supersede any treaty provision. That's all in Article 6 as well. So, I think it irons itself out in the end, because the system is meant to be flexible and to respond to changing circumstance.
Yeah, I'm sorry, just very briefly. Yes, the system is designed to be flexible and respond to changing circumstances. That's my complaint about Chief Justice Roberts' opinion, is I think it does not understand that it does not adequately recognize that the system, to my mind, includes the court's interpretation of treaties and the way in which it deals with treaties. I really agree with Jonathan. I think a lot of the problem with this decision is that the court goes down the self-execution rabbit hole. It could instead have done what I think the gentleman is suggesting. It could have gone for the vague foreign affairs authority kind of thing. Now, Chris is absolutely right. There are some serious problems with going down that particular rabbit hole. But the odd thing about the decision is that what the court does, so when I said it's a very formalist opinion, if you glance at it quickly, you would think, oh, no, this is actually quite a functionalist, flexible opinion, because it does the whole thing in this famous framework that we call Youngstown, which is based on an old case, that's supposed to be this sort of, we take into account, it's very flexible, and we look at the president versus Congress, and it's all about shifting, allocation of power depending on what issue you're talking about. But it combines that very flexible framework. So it says, okay, which zone of Youngstown are we in? Let's be flexible here. Okay, well, we must be in zone 3 because this is a non-self-executing treaty. And so then you're back down the self-execution rabbit hole. And so again, I really agree with John at the end of the day. I think this is just not a strong enough opinion for the legal analysis to really have legs.
Well, earlier, Melissa mentioned that Missouri versus Holland, and the question that comes up quite frequently about the extent to which treaties may expand congressional power. And for those that are interested, there's actually a cert petition pending now in a case called United States versus Bond. This would be its second trip to the court if the court accepts it, involving a woman who was prosecuted after she, I guess, tried to poison her husband's mistress, but was prosecuted under a chemical weapons treaty, or implementing legislation for a chemical weapons treaty. And the court previously held that she did have standing to raise this defense at trial, and that case, that cert petition is pending. So if the court accepts that, we may get some more clarity about the role of the treaty power and the scope of the inclusion of treaties in Article 6. But I'm getting the hook, so please join me in thanking our panelists. And I believe we are on break until all of you make the announcement.